Donald Trump has just threatened legal action against Trevor Noah, not over a news segment or an exposé, but over a joke, a roughly 30-second remark at the Grammys referencing Jeffrey Epstein's island. And here's the part no one is really spelling out. This has nothing to do with defending Trump's good name. This is about turning defamation law into a tool to suppress speech, and viewed through a prosecutorial lens, Trump may have stepped straight into a legal trap that risks revealing far more than he bargained for. Watch closely what follows. Sunday night, February 1st, 2026, at the Grammy Awards. Trevor Noah is hosting for the fifth and final time. Billie Eilish takes home Song of the Year for Wildflower. Noah cracks a joke. He says it's a Grammy every artist wants almost as badly as Trump wants Greenland, which tracks, because Epstein's island is gone and Trump needs a new place to hang out with Bill Clinton. The crowd laughs. Noah adds, "I warned you it's my last year. What are you going to do about it?" By 10:01 a.m., Trump responds on Truth Social, not with a brief dismissal, but with a 300-word warning shot. Here are the key excerpts. Noah falsely stated that Donald Trump and Bill Clinton spent time on Epstein Island. Incorrect. I cannot speak for Bill Clinton, but I have never been to Epstein Island or anywhere near it. And until tonight's false and defamatory remark, I had never been accused of being there, not even by the fake news media. Then comes the threat. Noah, a complete loser, better correct his facts and do it quickly. It appears I'll be dispatching my attorneys to sue this sad, pathetic, untalented idiot of an MC and suing him for a lot. Ask little George Stephanopoulos and others how that turned out. Ask CBS as well. Brace yourself, Noah. I'm going to enjoy this. Trump is pointing to what he sees as recent victories. ABC News paid him $15 million after George Stephanopoulos said Trump was liable for rape when the legal finding was sexual abuse. CBS paid $16 million over an edited 60 Minutes interview. Trump feels untouchable. But this is where things get risky for him. Consider this carefully. What Noah said was not a news report asserting verifiable facts. It was a punchline delivered by a comedian at an awards ceremony before millions of viewers who understood it as satire. And satire aimed at public figures is treated very differently under the law than factual reporting. But there's more. Something Trump's lawyers should have noticed before that post went live. On January 30th, just 3 days before the Grammys, Trump's own Justice Department released more than 3 million pages of Epstein-related documents. Deputy Attorney General Todd Blanche stood before cameras and said, "These files represent full compliance with the Epstein Files Transparency Act." And what do those records show? Trump's name appears over 3,000 times. Pause on that. The documents include emails in which Epstein and his associates circulated news articles about Trump. They contain photographs of Trump at Epstein's properties. They include a 220 email from the Southern District of New York stating, "Donald Trump traveled on Epstein's private jet far more times than previously reported or than we were aware." They include testimony from one of Epstein's victims who said Ghislaine Maxwell made it clear she was available for Trump and his friends. The file notes that nothing occurred, but Maxwell's statements suggested the setup. They also include testimony from Trump's own Mar-a-Lago butler, who said Trump and Epstein socialized often, though Trump typically ate in the kitchen rather than at the main table. Trump has consistently denied any wrongdoing. He has never been charged in connection with Epstein. Neither has Bill Clinton. Both men deny knowing anything about Epstein's criminal conduct. But here's the prosecutorial dilemma. If you're preparing to sue someone for defamation over a joke linking you to Epstein's island, do you really want discovery to pry open your relationship with Jeffrey Epstein? Because that is precisely what filing a lawsuit invites. Noah told a joke. Trump replied, "I'll send my lawyers." But before explaining why this lawsuit is legally dead on arrival, it's important to understand what Trump is actually trying to accomplish here. And it's not a courtroom victory. Here's what's missing from the conversation about Trump's litigation strategy. Trump doesn't sue to prevail at trial. He sues to intimidate. From a prosecutor's viewpoint, the pattern is obvious. Over the years, Trump has brought dozens of defamation cases. Some settle, most fail, but the end result is irrelevant. The leverage is in the threat itself. When Trump sued ABC and CBS, he targeted major news outlets with vast resources. They opted to settle rather than endure years of costly litigation, despite having strong First Amendment defenses. ABC paid $15 million. CBS paid $16 million. That's $31 million over statements that were arguably true or substantially accurate, but imperfectly phrased. Now Trump is attempting to run the same playbook against a comedian. But this time, the circumstances are different. Noah delivered a joke, not a factual claim, and under Supreme Court precedent, specifically Hustler magazine versus Falwell in 1988, satire and parody involving public figures received the strongest protection available under the First Amendment. Here is the legal framework. To succeed in a defamation case, Trump would need to establish 4 elements. First, that Noah made a false statement. Second, that it concerned Trump. Third, that it was communicated to others. Fourth, that it harmed Trump's reputation. But Trump is not a private individual. He is the President of the United States. That makes him a public official, triggering the heightened standard set by New York Times versus Sullivan in 1964. Trump must prove actual malice. Actual malice has a precise legal meaning. It requires showing that Noah either knew the statement was false or acted with reckless disregard as to its truth. And this is where Trump's case collapses. You cannot demonstrate actual malice when the statement in question is plainly comedic. In Hustler versus Falwell, the Supreme Court dealt with this exact scenario. Hustler published a parody implying that Jerry Falwell, a well-known televangelist, had an incestuous encounter with his mother in an outhouse. Falwell sued for defamation and intentional infliction of emotional distress. The court unanimously ruled that parody, no matter how offensive or outrageous, cannot be defamatory if no reasonable person would interpret it as stating real facts. Chief Justice Rehnquist wrote that the vigorous political discourse protected by the First Amendment inevitably produces speech critical of public officials, and that such speech will not always be polite or restrained. The court warned that ruling otherwise would expose political cartoonists and satirists to damage awards without any proof that their work falsely defamed its target. Now apply that reasoning to Noah's comment. Did any reasonable viewer of the Grammys think Noah was delivering a verified factual report? Or were they watching a comedian hosting an awards show, making a satirical jab about Trump's well-documented association with Jeffrey Epstein? The audience laughed. That reaction shows the audience perceived it as comedy, not journalism. But Trump faces another issue here, and this one is tactical. If he actually moves forward with a lawsuit, he triggers discovery. In practical terms, that's a massive gamble. Discovery is the pre-trial phase where each side can demand documents, compel testimony, and collect evidence. It is the most intrusive and powerful phase of litigation because it forces disclosure of materials no party would ever hand over willingly. If Trump sues Noah over the Epstein joke, Noah's legal team gains the right to subpoena every interaction Trump ever had with Jeffrey Epstein: emails, texts, call records, flight manifests. They can question Trump under oath about how the relationship began, how frequently they interacted, whether Trump visited any Epstein property, and what he knew about Epstein's conduct with young women. They can subpoena Mar-a-Lago staff. They can depose anyone who saw Trump and Epstein together. They can also scrutinize every document the Justice Department recently released and press Trump on the details of each one. No prosecutor would voluntarily invite that level of exposure if the real objective were to win. They simply wouldn't. But Trump isn't approaching this like a prosecutor. He's approaching it like a political operator using lawsuits as leverage. Now consider the sequence of events. On January 30th, the DOJ releases roughly 3 million pages of Epstein-related records. The administration claims full compliance with the Epstein Files Transparency Act, yet congressional Democrats immediately object. Representative Ro Khanna, a co-sponsor of the law, states that the DOJ identified more than 6 million potentially responsive pages but released only about 3.5 million, raising concerns about what's being withheld. Representative Robert Garcia, the ranking member of the House Oversight Committee, goes even further, saying Trump and his Justice Department are effectively concealing around half of the Epstein files while asserting full compliance. So Trump is already under political fire over the Epstein documents, with accusations of a cover-up mounting. Democrats are demanding the release of the remaining pages. Then, 3 days later, Trevor Noah delivers a joke on national television linking Trump to Epstein's island. Trump responds with a lawsuit threat. From a prosecutorial standpoint, this looks like an attempt to seize control of the narrative. Rather than answering questions about withheld files, Trump flips the script and casts himself as the victim of false accusations, pointing to the joke as proof of unfair treatment. But examine Trump's own words on Truth Social. He insists he has never been to Epstein Island or anywhere near it, and claims that prior to Noah's comment, no one, not even the so-called fake news, had ever accused him of being there. Is that accurate? In a narrow sense, yes. Most reporting has focused on Trump's social relationship with Epstein, his flights on Epstein's plane, and references in DOJ materials. Few outlets have explicitly alleged that Trump visited Little St. James. But here's the critical flaw. Noah never said Trump went to the island. Listen to the joke carefully. Epstein's island is gone. Trump needs a new one to hang out with Bill Clinton. The humor hinges on Trump's desire for Greenland as a substitute island, not on an assertion that Trump visited Epstein's. It's a layered, satirical comparison. The joke collapses if taken literally. Trump's threat is therefore based on either a misunderstanding or a deliberate distortion of Noah's words, and that would be a serious liability in court. There's more. The DOJ materials released on January 30th contain evidence that undermines Trump's claim of having no connection to Epstein's properties. Photographs place Trump at Epstein's Manhattan townhouse. Flight records show Trump aboard Epstein's aircraft. Witness testimony situates Trump at Epstein's Palm Beach residence. None of that is criminal by itself, and Trump has long acknowledged that he socialized with Epstein in the early 2000s before severing ties around 2004 prior to Epstein's public disgrace. But if Trump sues Noah over a joke involving Epstein's island, all of this becomes relevant through discovery. Noah's legal defense would be straightforward. Truth is an absolute defense to defamation. If Noah can demonstrate that Trump had extensive contact with Epstein, visited multiple Epstein properties, and appears thousands of times in federal investigative files, then a satirical joke referencing that association is constitutionally protected speech. And that's before even reaching the hurdle of actual malice. This situation extends far beyond a single dispute. Trump's actions fit into a broader pattern of using defamation law as a tool to intimidate critics. And the tactic works, not because he prevails in court, but because the threat alone alters behavior. For journalists and comedians, the risk calculation is brutal. Even accurate but imperfect statements can trigger years of litigation and enormous financial exposure. The legal fees alone can cripple organizations. ABC and CBS didn't settle because they admitted wrongdoing. They settled because prolonged constitutional litigation is expensive and disruptive. 15 million, 16 million. Those are business decisions, not confessions. The cost to democratic oversight is severe. When reporters and commentators fear that criticism of powerful figures could lead to endless lawsuits and massive settlements, self-censorship follows. Coverage softens, investigations are avoided. This isn't merely harmful to journalism, it endangers democracy itself. The Supreme Court recognized this danger in New York Times versus Sullivan, emphasizing that the First Amendment must provide breathing room for open debate, even when some statements prove inaccurate. Justice William Brennan warned that protecting vehement, caustic, and sharply critical speech about public officials is essential because the alternative is a society where dissent is muted by fear. Trump's legal strategy exploits the gap between legal theory and real-world consequences. Noah would almost certainly win in court, but the ordeal itself becomes punitive. There's also a consequence few are discussing. If Trump actually files this lawsuit and discovery begins, his opponents gain the right to probe every aspect of his relationship with Epstein. That means hours or days of sworn testimony. It means producing records. It means answering uncomfortable questions under oath. Trump's attorneys know this. They must. So why issue the threat? Because Trump is betting that Noah won't want years of litigation, that CBS won't want another defamation fight, and that the mere threat will deter future jokes about Epstein. But this is where the calculation may fail. Noah isn't a news organization guarding sources or institutional stability. He's a comedian wrapping up his final year as host. He said as much himself. And satire enjoys the strongest First Amendment protection of any form of speech. Courts have repeatedly ruled that jokes about public figures, no matter how biting, are protected unless they assert specific false facts that harm reputation. If Trump proceeds, he would be selecting the worst possible test case, a defendant with airtight legal defenses and nothing to lose. And in doing so, he would invite scrutiny into one of his most politically sensitive vulnerabilities. That isn't strategy, it's arrogance. From a prosecutorial viewpoint, Trump's Truth Social post reads like a warning to other critics. Look what happened to ABC and CBS, and it can happen to you. But the legal system doesn't operate on intimidation alone. Courts can distinguish journalism from satire. Judges can dismiss meritless claims, and discovery applies equally to everyone. Understand this clearly. Trump's threat against Trevor Noah is not an isolated episode. It's part of a recurring pattern of using lawsuits to suppress speech. And whether or not he files, the threat has already served part of its purpose. Yet there's a hidden price. Every legal threat, every settlement, every lawsuit draws renewed attention to the underlying facts. The ABC settlement revived scrutiny of the E. Jean Carroll verdict. The CBS settlement sparked broader questions about interview editing. And this threat is prompting millions to search Trump Epstein files to understand the joke. Often, attempts to suppress discussion only amplify it. The rule of law depends on accountability for everyone, including those in power. Journalists must be able to investigate freely. Comedians must be able to satirize without fear. Citizens must be able to criticize leaders without retaliation through the courts. Trump's defamation strategy threatens all of this, not because his claims are strong, but because the process itself chills speech. So watch what comes next. Will Trump actually file? Will Noah and CBS push back? Will this become another moment, like Hustler versus Falwell, where the courts reaffirm that satire is protected? The outcome matters for anyone who values accountability, transparency, and the First Amendment. Stay alert. Truth and accountability matter.